Very happy to have Professor Jody Madeira join us on this fascinating topic, which is very timely in the Canadian context, with a recent professional judgment in the case of Dr. Barwin in Ottawa. So I'll introduce the speakers. In the meantime, I will distribute the attendance list, as you know, for the students who are taking this course, and also for the others. You can add your name to the list so that we have a sense of who is attending. So let me briefly introduce Professor Jody Madeira and Michaël Lessard. Professor Madeira joined the Indiana Law Faculty in 2007. Her scholarly interests involve empirical research, the role of emotion in law, sociology of law, law, medicine, and bioethics, and the Second Amendment. Her most recent book, Taking Baby Steps, How Patients in Fertility Clinics Collaborate in Conception, was published in 2018 with the University of California Press. It shows how you can have catchy titles in this area. So she takes their readers inside the infertility experience, from dealing with infertility-related emotions, forming relationship, and so on. She also has a book, Killing McVeigh, the Death Penalty and the Myth of Closure, which looks at collective memory issues in criminal prosecution and sentencing. Her work in general is on bioethics, health law, and issues of theory of law in relation to that. So her talk is on understanding illicit insemination and fertility fraud from patient experience to legal reform. Afterwards, we will have a commentary by Michaël Lessard. It's always very good and very nice to be able to see to hear some of the work that our SJD students are doing. He's a SJD student here at the University of Toronto. He's also a lawyer. He did a master's in legal theory at NYU Law School. He has a double bachelor's in common and civil law of a good institution, which I also attended, McGill University, and he clerked for the Court of Appeal. He works on law of persons, bioethics, family law, and linguistic sexism. So without further ado, Professor Madeira, then Michaël Lessard, then we'll open it up for questions, and I think we'll have a good discussion with the people here. Thank you.
And so I'll just I'd like to say a few words about how I came upon this topic and sort of my own background. I'm not a lawyer necessarily by predilection. A lot of my friends knew that they wanted to be lawyers when they were 3 years old, and I took a different path. I have a master's in sociolinguistics, I have a PhD in communication studies, and I did my PhD concurrently with my law degree. When I was doing my PhD, I started out with a different research project. I looked at actually the trial and execution of Timothy McVeigh, the Oklahoma City bomber. Most of you probably were just, very, very young in 1995, if you were born at all. And what happened was there was a very racist guy who was involved in the militia movement, very into firearms and against the US government, and he blew up a federal building in Oklahoma City, and he killed almost 170 people. And what happened afterwards was the first of its kind in the United States. So in several senses, there was a terrorism trial of McVeigh and of his co-conspirator. And from the beginning, McVeigh was this very hard, defiant character. And his co-conspirator, Terry Nichols, had children. There was testimony at trial about how he would send his children cards with toothpaste, for ink. Very much the family man, and McVeigh was the loner. And so my thesis was that McVeigh's character and the way he was portrayed in the media, his communications in the media, made victims and family members, survivors, one might say, feel that he was personally in a relationship with them, that he was doing the media work to affect them, to harm them further. And that's why they wanted him to die, not from his role in the bombing. So using communication theory, I talked about something called a parasocial relationship, which is when you are you feel as if you are in a social relationship with somebody who you really don't know. Like the quintessential example is a weatherman, on the local news station. People like weathermen. They appear friendly. They appear to be someone that you would want to be friends with, in your social circle, or a character on a sitcom. This theory goes back, decades. But McVeigh actually, turns out McVeigh, according to his writings, was actually trying to affect victims' families through the media. And so that was the context of that book. And, but a very important concept came out of it for me, and that was that, number one, the media can play a role in how crimes are understood, in constructing a crime, one might say. And it's very important for victims to tell their stories in some way. And sometimes the court is not the right way to tell their stories. And again, this is coming out through these fertility fraud cases. So in my second book, which brought me directly into the world of fertility treatment, so I have triplets from IVF. They are now 12 years old. And I became very interested in how law scholars, even female law scholars, represented people undergoing fertility treatment as desperate. Desperate women will consent to have a child by any means, right? But yet these very same scholars did not have a problem saying women do great things when they decide to get abortion, or they are considering these other reproductive decisions. They have no problems deciding, to make these other reproductive decisions, only fertility treatment. And that's problematic, because if we don't trust women and trust couples and trust people to take care of their bodies in every circumstance, and then it undermines the concept of autonomy, I think, across the board. You can't just choose a context where you can trust reproductive decision making and say in other contexts it's problematic. And so I interviewed 130 men and women who had undergone IVF. I interviewed 83 medical professionals who worked in clinics, nurses, third-party donor coordinators, doctors, and that turned into the book, which dealt with everything from the emotional experience of IVF to how people form relationships with their doctors, the trust involved in the doctor relationship, to informed consent. And so I was giving a talk on the book when my book came to the attention of a journalist in Indianapolis. And it just so happened that in 2017, in December, a guy by the name of Donald Klein was being sentenced for using his sperm on women in the 1970s and 80s to inseminate them without their consent. And in many cases, he would tell them, oh, the sperm's from your husband. Oh, the sperm's from a donor, a medical resident that looks like your husband. And in reality, it was his own. So I think this fertility fraud fact pattern is really one of the only fact patterns I can foresee where you might have the issue of reproductive decision making and closure in crime on the other hand, and this brings them together. And so I look at this through a particular lens. So what I am doing now is one might say, consult with people who have been in these circumstances. I let them know what their options are. I do not practice law, but I try to talk it through neutrally. I connect them with lawyers. I connect them with other people, social media groups of others who are going through this. I'm serving as an expert witness for free if people need it, and I'm interviewing individuals who have gone through this, and it's going to be the subject of at least one academic book at this point. So I think the story of fertility fraud is the story of how we seek accountability, how we deal with perpetrators, how we overcome what we perceive to be our own bodily weaknesses, such as the male stigma associated with, male infertility, and how we cope with trauma, right? How we cope with trauma when we find out we were essentially raped 30 years ago and we didn't know it at the time. How we cope with the trauma of knowing that this person who we allowed into our body, right, who unknowingly took advantage of that to invade our family tree, how we deal with that knowledge when this seems so far in the past, right, but suddenly rushes into the present. And just as a note, I'd like to say that reproductive technologies always historically have roots in deception. So much of our gynecological knowledge comes from the experiments of James Marion Sims, who is looked at the father of gynecology, but who actually did a number of experiments on slaves. The first artificial insemination took place, steps away from where I went to law school, on Sansom Street in Philadelphia. And in 1884, in the Jefferson Medical College, a woman came in, the wife of a merchant, who could not have a child, probably because her husband had non-viable sperm. And so the doctor selected the most handsome medical student, convened his class, and anesthetized the woman with chloroform, laid her out on the floor of on the table of an observation classroom, and inseminated her with the med student's sperm in front of the entire class. This came out in the 1920s when someone who had witnessed this procedure published an article about it. So in the prototypical fertility fraud case, there's an adult who takes a direct-to-consumer genetic test like 23andMe, Ancestry.com, MyHeritage, and gets the results back only to find out that, lo and behold, he or she has many half-siblings. Her parents may tell her at that point, well, you're donor conceived. Some of these individuals have no idea that they were conceived with donor sperm. So it's a double deception, right? It's not only that their father, biological father, is their mom's fertility doctor, but it turns out that they are not the biological child of their father with whom they grew up. And sometimes the parents waver and try to say, no, this couldn't be. Sometimes they're very forthcoming. And when this person gets in contact with these new half-siblings, she finds out that maybe they're connected through a common relative that happens to have the same last name or also be connected with a relative of the doctor who treated their parents, or they all have the same fertility doctor in common, right? Their parents all went to the same clinic and provider. And so what usually happened as this story emerges is that the doctor and the couple, the parents, agreed that the woman would be inseminated with sperm either from the husband or from an anonymous male resident, male medical resident resembling the husband, or sometimes a mixture of the two kinds of sperm. When we look at how many cases we have worldwide, I would say the number is probably close to 30 or slightly over. It's higher if you consider all the cases. There have been cases that have been proven, the doctors have admitted it, but he has settled with the family and signed a non-disclosure agreement. So those cases involve doctors at the highest levels of medical administration. They involve doctors who have published articles on medical ethics. They involve doctors who have enforced sanctions on patients, sanctions on physicians for unethical conduct. So there's a lot of, one might say, hypocrisy in these cases. So the original was Cecil Jacobson, and he was a physician who was federally convicted in the mid-1990s, not for illicit insemination, but for telling women they were pregnant after giving them HCG, the pregnancy hormone, giving them ultrasounds and showing them parts of their body like fecal matter and intestines and telling them that was a fetus. And then around 3 months of pregnancy, he would say, well, actually the fetus died, and so you're not pregnant. And so he was convicted on a number of counts for mail fraud, wire fraud, and travel fraud, but not for the illicit inseminations themselves. Then we have this guy named Donald Klein. Donald Klein, when I started on the Donald Klein case, there were 23 people. We're now up to 70, and there's more emerging in every moment. There's times when they emerge, Amazon Prime Day, tests are cheaper, so a month later, there's a lot of new cases. Christmas, people, in the United States, unlike Europe, people think genetic testing is the next fun thing to do. It's a party game, right? And so they give each other these tests for Christmas, and lo and behold, their families, it turns out to be quite a dysfunctional decision. So Klein was prosecuted for obstruction of justice after a half-sibling, an unacknowledged child. And the rhetoric of this is difficult, right? So you want to say child, but really you can say individual who is doctor conceived, right? Because these are adult children, and it's infantilizing to say child. His unacknowledged daughter filed a consumer complaint with the Indiana Attorney General, where basically he was being investigated for bad sperm. Theft of honest trade practices is a close parallel. He did something wrong, sold the wrong product. And you can tell how difficult it is to bring these claims if that's what you have to resort to, right, in order to hold someone accountable. So the Attorney General sends notice out to Dr. Klein, and Klein's like, no, I didn't do anything like this, and I'll deny it, and the people who accuse me of this are guilty of defamation, and you should take action against them. He did not have a lawyer at the time. And the Attorney General says, that's really interesting, and let's send a prosecutor and a deputy out to his house. They give him a cheek swab, and lo and behold, he's lying. Surprise, right? So he is sentenced to a suspended sentence of 1 year in prison, which he has not, never has to serve, and fined $500 for lying to the state. But of course, this is obstruction of justice, so the victim is the state, not either the individuals who are doctor conceived through his actions or his former patients, right? So there is a lack of accountability there, and he's being civilly sued. He also lives in very close proximity to his patients. I've seen him at swim meets in Indiana, which is uncomfortable because he knows who I am. I've been on the media saying what a jerk he is. And there I am down on deck officiating a race where his granddaughter is swimming. That's great. I've seen him drive around in Bloomington, but that's not as bad as the people who live around him and the people who bump into his wife at the nail salon or at the hairdresser. Indianapolis is a very small city, right? Which also tells you the odds that 70 people that he conceived with his own sperm, at least, could have met and married, and this would be a different story with a different kind of harm. So here in Canada, there is the Norman Barwin case. It started at 11. I believe there's now 17. And there's, again, something very similar. This is a guy who was at the top of his profession. He had won medals. He was the president of the Canadian Fertility Society. And he did two things that were bad. He mixed up sperm samples. One wonders whether it's negligent or intentional. But he also used his own sperm. So he's being sued by the individuals who are doctor conceived and their parents, and also the men whose sperm samples he had stored and which were lost or contaminated. In the Netherlands, John Carbot, you might have as many as 200 individuals who might be related to him. He ran a clinic that was so dysfunctional, even the instances where he did not use his own sperm had massive record-keeping issues. The government tried to shut him down for record-keeping. He still kept practicing, and so they just essentially kicked him out of his clinic and took the records. And the physicians who looked at this at the behest of the state could not make sense and can never identify which donors, in fact, were received by which couples. I think there were, as of October, 50 people who had been identified and who are proceeding in a lawsuit in the Netherlands. We have, I think it's about up to 10 or 12 cases in the United States. We have one in Idaho, Vermont, Sacramento, California, multiple ones in New York, of course Indiana, Texas, California, Arizona, Colorado. Basically these are Iowa. These are popping up in the news routinely. And a very concerning twist has emerged in some of these fact patterns, and that's the news that some of these doctors then go on to deliver their own children, and then when the children, if their daughters are adults, he proceeds to give them pelvic and gynecological examinations as their father, knowing that he's their father. Of course, they do not know. So that's part of the allegations against the doctor with the initials GH in Sacramento. We've also had doctors who have sued, saying that their sperm was used without their consent. We have a doctor in Oregon who's suing for $5 million. He says, I donated 5 times for research purposes, but that's funny because I have 17 children. And so apparently I had sperm left laying around, and somebody used it to impregnate these women without my consent. And so that's a sort of reverse victimization. There's also a number of cases that are not public where individuals who are doctor conceived are trying to contact the children of the acknowledged children of the doctors. In some cases, the doctors are deceased. And the children of the acknowledged children of the doctors are refusing to communicate or give medical information to the individuals who are doctor conceived. And in some of those cases, there's really a need for medical information. There might be a virulent form of genetic cancer. There might be questions of genetically inherited arthritic conditions. Like in Klein's case, there was ankylosing spondylitis, right, which is an immune system disorder. So there is this need for continuing medical information, and they're trying to cut that off. And the question is, what rights do they have for this medical information that arose out of this fraudulent procedures? There's a lot of effects, and I'll talk about some of these throughout my talk. Former patients speak of feeling violated and assaulted. Families have been torn asunder because parents want to ignore the fact that this happened, half-siblings want to ignore the fact that this happened, and other half-siblings want to meet these new family members, want to seek accountability. So mothers and fathers love the children that they raise, and they're having a hard time separating the act of fraud that gave rise to the conception from the child who was conceived, right? So why would a doctor do this? Many of these doctors are pillars of their religious communities. They're Jewish, Catholic, or Mormon leaders. And that's just an observation. But it's interesting. There's some speculation, for example, that the church Klein belongs to believes in creating followers. And that might be taken in the literal sense with his actions, right? So we're not really sure. It might be a smart business practice, and this is, I think, what a smart business practice that seems really smart as long as you're not discovered, right? This way you don't have to go out and find donors with unpredictable menstrual cycles. You don't have to coordinate donors. You can also pocket the donation fee. And several of these doctors have said, we were just trying to help desperate women, right? Perhaps what I did wrong was I cared too much. And of course, we can plug all we know about desperation into those assertions. They simply knew that they could get away with it. Genetic testing is la-la land in the 70s and 80s. There's one case, by the way, in the 40s and 50s. Certainly at that time, you know, this was la-la land. It was even la-la land in the 1970s and 80s, right? And why would these people ever have to take a paternity test? Because they knew their child was donor conceived from an anonymous donor, right? Sometimes there are these creepy, darker reasons that emerge. Klein said, for example, I knew you in your mother's womb, quoting a line from the Bible, from Jeremiah. Really? Ew. There's mental health issues, right? There might be sexual perversions. One of the reasons why I explain what fertility fraud is because many people don't see that sexual component. But when the doctor is masturbating to produce a sperm sample in a room fairly close in proximity to the room where a woman is waiting, undressed from the waist down, with her legs spread apart in stirrups and a sheet over her knees, waiting for the donor sperm, what could you presume the doctor could be thinking of, right? And it's very interesting that in the cases in the United States that have advanced this far in litigation, the doctors say, yes, I knew it was wrong, but I didn't produce the sample in the clinic. It's interesting. So they're trying to separate the act of their masturbation. One of them said he did it at home. Like, I'm not sure that's any better. So another has said, I froze my sperm in the early 1970s when I was a medical student. Unless you're like Einstein's grandson, I don't think that's really happening, because sperm's very easy to come by for medical residents at that time, and a medical resident is a medical resident. You know, and so in 1986, I just summoned my sperm back from, you know, the bank where it was frozen, and I used that. Well, thank you. Now you're using sperm frozen according to these ancient technologies, right? And so either you're lying or you're guilty of medical malpractice, right? So choose one. What was the standard of care at the time? In the 1970s and 80s, fresh sperm was much more viable than frozen sperm. The freezing techniques weren't great even in the early 1980s. It was standard practice to tell patients not to attempt to discover their donors' identities. Male infertility was heavily stigmatized. Women who underwent insemination didn't even discuss it with their husbands. In fact, they wanted to keep their husband's secret. Of course, they still want to keep their husband's secret decades later when this fertility fraud comes to light. So that explains why a lot of the men don't participate in public accountability seeking, and why women are reluctant to do so if they were his former patients. It's different for lesbian couples. We have one doctor, although this has not emerged. The case is public, but there was one doctor who did help lesbian couples. And unlike the secrecy that pervaded the heterosexual artificial insemination treatment context, lesbian couples were on the phone to each other saying, this guy will help us. You know, go to this state and he will help you too, right? Because doctors didn't really want to help same-sex couples back then. Same with single women. These cases are both like and unlike other legal fact patterns. There are some cases that involve misappropriation or use of eggs and sperm. That's due to negligence, whereas this is intentional. There might be rape by deception cases, right? An individual fraudulently obtains consent to sexual activity. by pretending to be a partner or by misrepresenting a sex act. Well, here, they didn't think it was sexual, they thought it was medical treatment. So you can't even say that they consented to any kind of sexual act, even under false pretenses. This is often compared to so-called wrongful life and wrongful birth cases. Parents sue, claiming it would have been better if a child had not been born in wrongful birth cases, or a child sues, claiming that it would have been better for that child not to have been born in wrongful life cases. But here, that's not what they're asserting, because the parents love their child, but they are very dismayed to find that their autonomy was violated so profoundly. You can also look at fertility fraud through many research lenses. It might be about the effects of direct-to-consumer genetic testing and new genetic relationships, or about the ethics of disclosing parenthood to children, or about gender and feminism and the secrecy and stigma of male infertility. It could be assessed from the perspective of what it means to be a parent, biological versus psychological parentage, or from the perspective of medical ethics, what the doctor did was wrong, violating patient autonomy. Or we could look at it through the lens of criminal law, fraud, or civil law, torts, or contract law, right? And the stance depends often on whether this touch is seen as sexual on one hand or clinical on the other. Some might not see this topic as a serious injury, because after all, you had a child, that's what you wanted, who cares? Or they'll say, oh, be just glad that the sperm was from a doctor and not a janitor. Very classist, right? People might not want to bring these cases public because they're afraid of sensationalist reactions. They still like their doctor even though they know he betrayed them. They might think that this doctor is selfless. You know, in Klein's sentencing proceeding, his friends and family wrote letters to the judge about how hard it must have been for him to disappoint patients when there was no donor. And so he's doing it out of the goodness of his heart. Dr. Klein's always put his patients first. Empathetic and full of compassion, he sought ways to help families through this most tender period when both husband and wife felt helpless. This not only assumes patients' desperation, but it uses it as a sword against them, right? When it should be a shield that motivates courts and others to protect their autonomy. So why is it hard to hold these physicians accountable? If they're seen as wrongful life or wrongful birth cases, states just throw them out. In the United States, very few courts allow these claims because they say a child is a child no matter what health conditions the child has or how the child was conceived. But sometimes there's more fundamental reasons too. There's a lot of time that has passed, right? There's a lack of evidence. Very few people, except for one case in Texas, have their medical records that show they did not choose the doctor, right? That's preposterous to anyone who has gone through this treatment. There might be gaps in state law. For example, in criminal law, some states still require force, right, for rape or sexual assault. States might not have rape by deception laws, or there could be a wrinkle in proving that this is sexual and not clinical. That was why the prosecutor declined to bring sex assault charges in the Klein case. He said women consented to a clinical act. Yeah, but I'm not consenting to be inseminated with an elephant sperm. You know, that would be a fundamentally different procedure than artificial insemination with a human sperm. Still different than with the sperm of a particular human, right? They had chosen a particular human. It was an anonymous donor resembling the husband or the husband himself, right? Not the doctor. And when we look at the intricacies of different state laws, we see that sometimes state law doesn't even map onto this offense. And so fraud in Indiana is identity fraud or credit card theft, right? There's a misdemeanor called criminal deception, but it requires that you not only deceive a victim, but then affirm that you did not deceive the victim, right? So it would be like, I give you the wrong sperm, and the patients come back and say, is that the right sperm? And client says, yes. But it's not like the sperm that is illicit glows, wah, wah. No, it is just like any other sperm, right? It is not, you can't tell unless you check the label, and it's actually, the label actually said Donald Klein, right? That it was fraudulent. For civil law, there is another wrinkle. If you say this is intentional torts, like lack of informed consent or battery, and unconsented to touching, then insurance, which is the only real deep pocket to reach, might not cover it because insurance does not cover intentional torts. It would only cover negligence. Criminal law, again, I think I've talked mostly about the criminal laws. So there has been a novel state response to these difficulties. There's been legislation that have been created. For example, in Indiana, we actually created a cause of action for fertility fraud that says you can sue for this offense called fertility fraud when a physician uses gametes without the consent of the creator or the recipient. It's a felony. It allows all of these individuals involved, the former patient, the female former patient, her partner, and the individual child who is doctor conceived to bring a charge. Texas has a fertility fraud law that is sexual assault. It says this doctor basically takes advantage of a vulnerable patient, just like a mental health professional who sleeps with or is sexual towards his client takes advantage of that client, and has a sex offender reporting requirement that goes with it. That is not an approach that other states have followed. So right now we have California, Indiana, Texas. It was introduced yesterday in Ohio. It was passed out of committee in Colorado. Florida has a pending law, and Nebraska is heard it in their legislature yesterday. So, and again, these laws are being pushed by victims who try to seek accountability only to have doors slammed in their faces. Why is this a harm? And I'm running out of time, so I'll wrap it up soon. First of all, people have interest in being treated by a physician who fulfills ethical duties to patients. Do no harm, respect autonomy. Tell the truth. Patients have an interest in receiving appropriately screened gametes. And it's true that, even if Klein's sperm passed along cystic fibrosis or an immune disorder, that would not have been caught by testing at the time. However, the donation was not appropriately screened in the sense that it was not the sperm of belonging to a donor that they expected or like that expected. They have an interest in protecting anonymity. Here, this interest is particularly interesting because doctors like Klein said goodbye at 12 weeks and never saw his patients again unless they came back. But other doctors delivered their own children and then proceeded to proceeded to be the gynecologist for these former patients and sometimes their children moving forward. And so they saw the children grow up. And it's sort of like discovering your next door neighbor is your sperm donor, and your next door neighbor creepily watched your child grow up and knew that it was his child and took pride in your child's accomplishments, but you never had any knowledge of that. And meanwhile, you shared all this information with your neighbor, not knowing that there was this double relationship. So this interest in anonymity is not just on the part of the donor, it's also on the part of parents, protecting their right to parent as they see fit. There's all kinds of problems with pursuing anonymity in third-party reproduction with egg and sperm donation, and we can get into that in questions. For example, if you look at this through the lens of the rights of the child, it's a very different result, right? But this knowledge gives the doctor more power over his former patients. And it's actually, again, this invasion of the family tree. They have an interest in being touched by a physician with proper motives, not a sexual motive. And the donor-conceived children also have interests as well. They have an interest in knowing their medical history, in meeting other paternal relatives. They might have an interest in child support. Because in the United States, donors have to waive parental rights. None of the doctors signed anything. They are never donors in the legal sense. So we have two standards. Give your sperm to a physician prior to the transfer. Ha ha ha, here's my sperm, I'm transferring it to a physician, right? They are doctors, so they technically meet that. But the donors always have to sign a paper that says, I will not, I give up parental rights. I give up control of sperm samples. And they never did that. So there is an argument for child custody, child support proceedings. They have an interest in knowing what steps have been taken to limit consanguineous relationships. So right now, if you talk to people in Indianapolis, their children are coming to the age where they're dating, marrying. Some are, going to college, joining the military. And they say, I want to genetically test every person who my child brings home as a boyfriend or girlfriend, because I don't know if I'm related to them, right? And that's scary. That affects not only the immediate children, but also the grandchildren, right? I would say that interest is a serious interest only in a very few cases. Norman Barwin, perhaps, if we find out that these sperm samples got used inappropriately. Definitely the Jan Carbat case, because Netherlands is roughly the size of Oregon, and there's a higher chance of intermarriage there. Indianapolis, right? Klein was the only guy who used fresh sperm in Indiana. Easily foreseeable that this kind of thing could happen. And they also have an interest in anonymity. But they also have, it's sort of like being safe from these power plays, being safe from being examined by your father, who's a gynecologist, might be one iteration. But I think they have a greater protection for rights to know and protect their identity data. And this comes not from US law, but from the UN Convention on the Rights of the Child and European Convention on Human Rights language, right? When we look at how fertility fraud is experienced, mothers are primarily involved in seeking accountability. There's no fathers in any of the cases that are involved, other than as a name on a lawsuit. They don't really appear in public or talk, give media interviews, which I think reflects the definite influence of male stigma. They feel violated, they feel raped. They see this as a form of sexual assault. There's no doubt in their minds that this had a sexual motive. And they're unlikely to see Klein as remorseful. They don't expect to get answers to their questions as to why. They also feel very conflicted. They love their child. They loved their doctor. But now they found out that their child was conceived through this horrible process, and this very eminent man they respected is thrown off his pedestal. So they also have a very different experience than these half-siblings. So the half-siblings have formed social media communities like Facebook groups, and they talk to one another. And any community that's founded around a particular issue will eventually move beyond that issue if it continues to exist. So the half-siblings now meet and they go to movies together, their children play together. They are, in a sense, becoming friends or family, depending on your perspective. Their relationship to each other is not premised upon Klein, in other words. They have independent bases for liking each other and getting together. But the former patients, their parents, on the other hand, are still living in the world where they were victimized by Klein because they're not part of these networks, right? And they always are in, their relationships with the half-siblings are always mediated through what happened, in Klein's office all those decades ago. And so for the half-siblings, again, particularly in the Klein case, where I've done most of the interviews, this has emerged into not a silver lining, but they've decided to make lemonade out of lemons, one might say. They're angry about what happened, but they realize that that does not define them, and it doesn't have to define their interrelationships. So what they do to sort of get even is they became advocates. They told their story to the media. They wanted Klein to be held accountable. They sued. They pushed for the fertility fraud law, right? And that creates differences in the sibling community because a lot of this advocacy was done by people who came on the scene early on, part of the group of 8 siblings who were present when these charges first became known. However, people just found out a couple of weeks ago, right? These people feel like there's nothing left for them to do. So what they've done is they get plugged into networks with half-siblings in other states, and they start working on other state laws. So in the Nebraska situation, when Nebraska's law was heard yesterday, there was a network of half-siblings that submitted written testimony, coordinated through the Klein siblings in part, and from one person in Texas, and it became this big whomp. Here's good reasons why you should pass this law, right? And it's not just people in Nebraska who are hurt. There's probably an N of 5 in those cases, right? One family. But it became a network of people who have been harmed and who demand a response, not of one state, but of multiple states, right? They're subject to changing family dynamics. They're, in some cases, estranged from their parents because their parents don't want to pursue any charges or want to pretend it never happened, and they feel that that's the wrong thing to do. Potentially estranged from half-siblings. They feel at war with themselves. One of the people who discovered the Klein case first is a practicing Catholic. and feels that the way in which she was conceived was a sin, right? She's actually born from sin in two senses. Some wonder if they're inheriting any mental illness that their fathers, biological fathers, may have had that led them to this illicit insemination. I think that pretty much is their sense. They don't want money, as they're not seeking money, they're seeking accountability, they're seeking change, so other people do not have to go through it. But the irony is that given this laws that are now in place for using sperm, the chances that this will happen in the future are slim to none, right? And so they're focused on, well, maybe people will use these embryos that are so-called abandoned. Couples leave embryos there. They don't know who created them. They can't get in touch with people to destroy the embryos. And so these embryos are just laying around in fertility clinics. But then again, that's really not the same, because it's not, the embryo would still be from an anonymous couple in a sense. It would not be the doctor's own embryo. So there's a big question. We have to look at how likely this is to happen in the future. We have to look at the duty of the state to be responsive to crimes that are just being uncovered now, even though they occurred decades ago. We have to look at the state's relationship with regulating technology, particularly in the United States when assisted reproductive technology is almost entirely unregulated. The idea that this would ever be regulated on a federal level is almost non-existent. And I think it comes back to this principle of, why do we pass laws? How do we pass laws? Do we pass laws on the back of stories that are emotional? Do we pass laws on the back of statistics and social science? And what are these laws supposed to do? Essentially what we're looking at right now, I would contend, is the construction, the social construction of a new cause of action, of a new way to talk about reproductive injury, of a new way to talk about autonomy, right, through donor conception, of a new way to envision children's rights, and the rights of vis-a-vis institutions like clinics and doctors. So I think we're still grasping how to look and examine these cases. And so it's with that I'll turn to my commentator. Thank you very much.
I want to use this as well.
English is a second language, right? I wrote something. All right. Well, thank you very much for this paper. It's quite a rich paper, and it offers, in my view, in a sense, kind of a case study of some of the structural and conceptual challenges that health law is facing today. These cases of fertility fraud that Professor Madeira brought to light tells us something not only about law's gaps, but also about law's core. And this paper is quite helpful to have a productive discussion about health law in general. And so in that regard, there are three elements that I'd like to highlight in this paper. First, it seems to me that this paper really exemplifies the tension between our social understanding of medical consent and sexual consent. And I want to emphasize that I'm talking about our social understanding, but I think it also enters into our legal understanding of both types of consent. And so this tension arises when reproductive body parts are involved. In such a situation, the concept of medical consent remains unchanged, at least from the point of view of the doctors. You simply need to obtain informed consent to perform a medical procedure. However, the patient's expectations, in my view, seem quite higher than in other medical procedures. And similarly to sexual consent, they expect, rightly in my view, to receive a greater amount of information. And they also expect to have the practical ability to withdraw their consent at any time, which is rather more an issue for obstetric violence prevention than in this case. And in the case of illicit insemination, the problem really is really around the amount of information needed to obtain a valid consent. And so in a lot of the cases mentioned in this paper, some doctors and lawyers argued that the mother's consent was valid. They knew that what the medical procedure was. They consented to this procedure, and so they simply did not know who the genetic donor was, but they consented to the medical act. But from the point of view of the mothers, even though they consented to the invasive medical procedure at the time, to the doctor's touch, they feel betrayed because their consent was not merely about the clinical act, but about the whole context, the whole situation. And so the clinical act occurred in a situation quite different than what they expected. That is, as Professor Madeira mentioned, the doctor was inseminating his own sperm, collected a few minutes or a few hours before the clinical act, sometimes a few rooms next to them or allegedly at their house. But it's quite a very different context than what they imagined. And so the result of this betrayal was, among some others, the feeling of having been raped. And this is what happens when doctor exceeds the limits of medical consent, when reproductive parts are involved. You rapidly enter the realm of sexual invasion, of bodily integrity. And so Judith, one of Klein's victims, said in the paper, I feel I had been raped because the definition of medical touch and medical thinking is very clinically oriented, and touch following an orgasmic experience or ejaculation experience is much different. And you also mentioned two donor-conceived children, Judge and Maggie, who said that they felt they were the produce of rape. So to solve this tension between some doctors' conception of informed consent and the patient's expectations, I believe we should import some elements of our understanding of sexual consent into the notion of informed consent. And in a way, we are already doing so in law. It seems to me that our legal conception of informed consent is thick enough, at least in Canadian law, so that doctors' argument that the mothers provided informed consent because they consented to the clinical procedure, this argument would not hold in court. But it is telling that some people, some doctors and some lawyers still adhere to this understanding of medical consent. And this leads this paper really underlies that physicians may decide in practice the amount of information they give to their patients. So these cases of illicit insemination underscore that the medical practice is structured in a way that gives the doctors the power to decide the amount of information they provide. And one of the children, James, highlights that when he said, it's this idea that there is an enlightened wise man. They're free to make decisions for you. They're free to decide how much information is enough for you. And I can definitely see how problems start creeping in if there is no way to hold them accountable or know what they have done, or know that they have done something wrong. I wonder where else doctors can truly be caught yet. And I would start wondering what else we will see in the future. And so Professor Madeira's work really demonstrates the necessity to develop laws that put pressure on this asymmetry of information between doctors and patients. By controlling the amount of information provided to patients, doctors may control their consent. And if the medical procedure is successful, like in these cases, then it is hard to realize that some precious information was withheld. And such situations invite us to question our conception of informed consent that allows generally for some information to remain undisclosed. So my third and last point is that Professor Madeira's paper also highlights the difficulty for parents and children to determine what is the harm done by doctors. what is the injury suffered. And from a legal point of view, it seems to me that we could easily say that the harm done is a violation of these female patients' bodily integrity. But for those families, it's really hard, and as you mentioned at the end of your talk, it's really difficult to distinguish this view from the existence of their child. And so suing the doctors in a way is felt like rejecting your child. And one of the children, James again, acknowledges that when he talks about his mother who is unlikely to supply, and he says, "My mom is also in a sort of emotional conflict. From her perspective, she loves our kids. It couldn't have been that wrong because we are here, right?" And such reactions suggest the importance of distinguishing a violation of one's integrity with the result of such violation. The violation is wrong even though one may love the children that comes out of it. These are two different things. And so to conclude, Professor Madeira's paper is quite rich as it goes beyond illicit insemination to reveal deep challenges that health law and our social understanding of health law faces. Thank you for your paper.
So we'll open it up for questions, but let me take the opportunity to start with one.
Unfair.
Then we'll go to the student, but it's related a little bit to what Michael raised. So in the context of the debate around donor anonymity, one of the arguments that is often put forward is that those who claim for some kind of right to genetic identity are driven by a sense of genetic determinism, or making the mistake of genetic determinism. And many of your arguments in your paper related to the harms that are inflicted upon the people who have been fraudulent or involved in this procedure, or the victims of these procedures, are often intuitive, symbolic, related to taboo, related to analogies of rape, and I think they reflect a kind of indeed very rich concept of personhood, of what harms means to individuals. So they seem to kind of contradict the arguments that are made in the anonymity debate. Have you kind of brought up these issues as well, or how would you connect these kind of arguments?
So I think we have to first identify the issues in the anonymity debate, right? So the right to medical, I think this is something that I'm just starting to penetrate, because when, this issue is so new to me as well, and I'm at the level where I'm still scrambling to work with cases and people, that sometimes these deeper questions, they come up in response to particular cases, or in interactions like this, where I'm thinking about this more in an intellectual instead of practical or legal sense, like on the ground. And so, I think that when you have, particular, I'll just take the right to know medical information, or the right to know your family, right? That really cuts both ways here, because the way they're asserting it is they want a particular kind of information. They don't want to know their family members. They don't want to know the doctor's relatives so much as they want to know what diseases they might have, right? Which also implicates the right of the doctor's acknowledged children and relatives to have privacy and to not know what they might have, right? So they might, it's entirely possible that there's somebody who has a genetic cancer on the half-sibling donor-conceived side, doctor-conceived side, but in the acknowledged children, there's no knowledge of this condition, right? So this information exchange gives unwelcome information to that side as well. Even above and beyond, like, my father did this, to other people. Now we have this information about something undesirable in their background. And so I think that it does undercut these arguments in particular ways if you look at these individual cases. But if you look upon this at a surface level, at least you can say well, then they can make healthcare decisions, right, that they otherwise would not be able to have. They might be able to, I don't see any warm, fuzzy relationships coming out between the doctor-conceived individuals and these other family members, but surprisingly, there have been these warm, fuzzy relationships. Sometimes the way that they find the doctor is through a sister of the doctor, or another relative of the doctor, and this relative hears of what the doctor did and says, we have a case that's pending in Vermont where the doctor's sister was estranged from the doctor. Doctor's sister actually gave a large inheritance to the doctor-conceived individuals in the will, bypassing her own nieces and nephews. And so if the outcome of this case, in some part, that the will is separate from this. They, upon proving the genetic relationship, get the money, but there's now an independent reason why the doctor's acknowledged family would not like these because they think, oh, you're invading our family relationships as well. But I think the more you get down to the gut, down to the individual facts of these cases, the more they seem to problematize the general reasons, the general arguments that you have, right? And the less it seems about making health decisions and the right to know one's family. But I think that's any type of legal claim.
Okay.
Does that?
Yeah.
That's something I never thought about before.
Hannah, you can move on.
Yes.
Okay.
I apologize in advance. This question hasn't really crystallized in my brain as much as I would like, but I found one of the perspectives of the children, the doctor-conceived children in the case, fascinating, the ones that had a difficulty conceptualizing themselves and their own lives as a mistake. And so I'm wondering how that kind of ambivalent reaction maps onto the legal repercussions in terms of whether or not the donor-conceived children have any claim under tort or criminal law, either as criminal complainants or as applicants in a tort. I'm having difficulty understanding how one can claim that they suffered emotional trauma if the alternative was that they wouldn't exist.
Yes, yes. And that, I think, is one of the conceptions. So I think, as we've talked about today, it's easier to see the harm suffered by the female patient who was strictly, inseminated. It's easier to see the claims of a partner who expected that his sperm would be used and he'd have a genetic relationship with the child. The interests that are hardest to identify, frankly, are those husbands who had agreed to use donor sperm and the interests of the children. Some courts, actually one court in the Mortimer versus Rowlett case from Idaho, have explicitly said, doctor seeks a motion to dismiss, and the judge grants it saying, well, here, you weren't even in existence when the harm occurred. You weren't conceived yet. So you can't be a patient of the doctor, and you can't be so you couldn't have suffered malpractice. And so I usually answer those questions by saying, yes, but doctors owe duties to people who aren't patients all the time, right? So if one of the cases that's well known in the United States is a case where a doctor gives an HIV, a transfusion with HIV-infected blood unknowingly to a 12-year-old female. Does not tell her parents, even when he finds out 2 days later that the blood was infected. And then child grows up, has a sexual relationship with a man, man gets HIV. And it's, by this point, the former patient has full-blown AIDS, dies of AIDS, and the doctor is sued by the boyfriend. And he says, I didn't know you were in existence. Where did you come from? I don't owe a duty to you. And the court says, well, actually you do, because it's foreseeable that had you told the patient or the patient's family, they could have protected other people with whom she came in contact, right? She could have decided not to have a sexual relationship with somebody or told them prior, but because she didn't know, she could not protect third parties. So the doctor owed a duty, even though he didn't know, this boyfriend, because it's foreseeable people grow up and have sex, right? It's one of the most foreseeable things ever. And so you don't need a patient relationship. And so I think that it's largely the strange result of an Idaho wrinkle. that isn't going to be found in other cases, but that's another reason why these state legislative reforms have another way to argue that same point was that it's distressing to family relations, right? So that my family is now dysfunctional because of what the doctor did, and that causes me distress, not necessarily knowing where I come from. Great question.
Good, sorry.
Sure. My question is like a little bit similar. I was just wondering what your opinion was on whether there should be like an ability for either children, I guess, or the parents to sue based on like if the doctor's sperm like had some kind of disease himself, and if like that should be tailored to the amount, how bad the disease was, and even potentially weighed against who the other sperm donor was going to be if they knew, and yeah, so what your thoughts are on that.
Yeah. And I'm sorry, can you repeat that last sentence?
The last sentence was, like, say the husband, whatever, he was expected, and he was, I don't know, say he's like a genius or something, compared to another situation where the husband wasn't, like, should those still be treated the same, according to the, like, should it be the difference between the doctor and the husband, or just, like, the diseases that the doctor had?
I think when you start looking at the subjective qualities of the people who produce the gametes, that opens the door to a lot of problems, because then you get into genetic determinism. And in some ways, legal, third-party reproduction is based on that premise. And sometimes I'm comfortable with that, and sometimes I'm not. When I'm comfortable with it, it's more like, okay, these gametes come from a Jewish donor, or these gametes come from a Pakistani donor. And it's like, I'm Pakistani, I want gametes from a person who's like me in terms of being Pakistani or being Jewish. And that, I think, is okay, right, if we allow third-party reproduction. But if we say, I want to I want a donor with particular intelligence, I want a donor who is good at music, I want a donor with blue eyes, that's when we start getting into subjectively bad territory. Because then, what if you find out in utero that the child is going to be, you chose a tall donor, and the child looks like it's going to, child-to-be, looks like it's going to be, have short femurs, right? Do you get an abortion, right? And so that opens up a lot of uncomfortable territory, because it's true that these, factors get passed down sometimes, musical talent or height or intelligence, but sometimes they don't, right? Or sometimes they take a particular twist. You don't get a good voice, you're good at guitar, And so it's just.
Where do you look for it though, right? Like there's like websites where they'll.
Oh, absolutely, and they pay more.
Right.
If your donor is an Ivy League college student, right? The weirdest scenarios I think I've seen. We have cases that have come before courts in the U.S. where the parents are told donor is PhD, genius, all of those great characteristics, no mental illnesses, good athlete, and it turns out that the donor is actually this paranoid schizophrenic who is a felon and has been in prison for violent crimes, and just was out when he decided to donate. And it even turns out that the clinic helped the donor to misrepresent his characteristics. Oh, don't you really mean you're a genius, right? And the courts have said, you can't say that this child from this particular undesirable donor was better than the donor that they thought a hypothetical child from the donor they thought they got.
Mm-hmm.
So courts refuse to compare.
Don't you think?
The what?
I feel like it's a bit of a probability game, because you never know what would happen, but.
Right.
Yeah. Exactly.
And a close comparison, I think, is on the will I be like my father question. We have memoirs and ruminations written by people whose parents were famous criminals. There have been a couple of books written by children who learn later that their parents were serial killers, and they say I feel like I live in the shadow of my father because he had this potential, doesn't lurk in me. And I think that's a question. That's one of those issues where it's very different doctrinally or theoretically than it is when you discuss individual cases.
Gabrielle?
You actually answered the question that I submitted, but I'd like to ask a different one if that's okay. I'm wondering about the jurisdictions where legal reform has been brought in already in the criminal sense. Mm-hmm. And I'm wondering whether you think that that it has a lot to do with the sort of the philosophies in those places behind the purpose of criminal law.
Yes.
And whether it's, you know, punitive or
Right.
coercive, yeah.
Yeah, and it's interesting because these criminal laws, let's look upon them just in the criminal sense. I think in the civil sense they do a lot of good because they allow people to bring claims that they otherwise might not be able to bring. And they say this is a harm, this is a tort, you know. But criminally, we're passing a law. Usually we pass laws that, you know, are good. They not only make a statement about what is wrong and what is right, but they also can be used to prosecute people for continuing violations. So murder occurred a week ago. You know somebody's probably going to get murdered in the future, and you can use that law. These laws probably will not get used, and they're passed after, you know, this very emotional testimony from these doctor-conceived children and their parents. And so you wonder whether they're feel-good laws. You know, you can construct a hypothetical where doctors could use these abandoned embryos without patients' consent, but it's unlikely, right? And so it's often occurred to me, why do we have this criminal law? You know, because it won't ever be used to prosecute the doctors because of ex post facto, right? You can't say, you can charge them under fraud, but you can never prosecute them under this fertility fraud law that was passed decades later. And so, and I think that's some of the criticisms of this legislation. Other potential issues that are adjacent to that are, by saying that this is sexual assault, do we trivialize the claims of people who have been through more traditional forms of rape or been through more traditional forms of sexual assault, right? That are usually forcible or that are more explicitly enmeshed in power disparities at the moment that the harm is occurring, right? So these patients were in a power disparity with their doctor in two cases, you know, the fraud sense and in the sense that they had less medical knowledge than their physician. But it's a different type of power disparity, and they did consent to that power disparity, you know, not to the fraud, but to the, I will go to someone who's more skilled than I am to figure this out. And so there's been opposition actually to the sexual assault laws in the United States, of which Texas is only one, because they've said, well, number one, sex assault is this, not that, right? Rape is this, not that. But also some of the, Judy Dar, who's on the ethics committee of the American Society for Reproductive Medicine, she's someone who's been thinking about this for decades. She says, wait, we worked so hard to separate the idea of sperm donation from the idea of sex, and what you're doing is putting the two together in a law, and that's bad. And my response to that usually is, well, you worked, yes, that's true. You did work so hard to separate sperm donation from sex or donation from sex, but you were so good at it and so successful that we automatically assume, we don't assume that the act of sperm donation is sexual anymore. And when the doctor's act, not the law, brings the two together, that's when we say ick, right?
If I can follow up,
yes.
question on that. So, do you think that actually the one problem with rape laws would be that the focus is too much on sex rather than on the fact that we're controlling someone else's body? I'm wondering if there's maybe a problem of discourse, and at the end of the day, it's also an act of, it's basically an act of control of sexual control over someone.
Yes, absolutely. And you know, the thing is, there's a catch-22 because you can't prove that this is sexual. You strongly suspect that in some cases, at least, there was a sexual component, particularly when the doctor goes back and performs pelvic examinations on his own daughter, right? There's something strange about that. But then you don't have
their head.
Exactly. There's no evidence. No doctor has already said has ever said, "Oh, I had a lovely blonde on my table today, and I used my own sperm, right? And I thought of her as I produced the sample." But you're never going to have that evidence. It's gross, right? It would be very strange to actually be able to make that connection. And so you harm the victims by making them produce evidence that is almost impossible to produce that this was sexual, right? But then you can say, I think if you make analogy to say this is sexual is almost to give into the trap that rape is sexual. Rape is an act of power, right? And I think this was an act of power. So you don't have to go into the sexual component of it to see it as akin to rape, you know?
David Lemmens.
Hi. Yeah, mine is kind of springboarding off of some of the things that you were just talking about with regard to the last question. I'm kind of interested in the accountability piece. And it sounds like it may be to a certain extent moot, given that these criminal laws, to the extent that they're passed, may not actually be used for these circumstances. But just thinking about criminal theory more generally, and what's the best way to be accountable for harms, I wonder to what extent in circumstances like this, I mean, there's growing research about how sexual assault as a criminal matter is often unsatisfying for victims, given that it doesn't give many answers. And I saw in this piece that a lot of the donor-produced children wanted those kind of answers. And I just wonder to what extent like a restorative process in certain circumstances may be a more appropriate response, or what your thoughts are about using the criminal law rather than other mechanisms.
Right, and I think part of this relates to how we're socially constructed to expect certain results, right? Like if something is a crime, then you must have criminal punishment and a certain level of criminal punishment. So in the capital punishment context, we have states where execution is an option, and if someone's loved one is murdered by an individual who's not executed, it seems to say something about how this wasn't as bad a murder, or this wasn't as good a victim, right, as in other cases where the offender's been executed, although it doesn't have anything to do with that, right? But we expect and we want the harshest punishment available, right? And I think right now in this case, they just want some punishment. Like here you had a criminal punishment in Klein's case, but it was entirely irrelevant to them because it was, oh, he lied to the state, you know? It wasn't until in a non-criminal proceeding, which was civil, that this guy's medical license was taken away, and the language was like, he did a moral wrong. It answered the illicit insemination and why that was a violation, and people loved that, you know? And they weren't after, certainly not an execution, they weren't after anything in particular. What they wanted was the state to acknowledge that this was some other type of harm through some proceeding. It didn't even have to be a criminal proceeding. And something that Klein valued was taken from him, his medical license, right? So the very act that he prided himself on, he screwed up with that, and that's why, you know, this most precious thing was taken away by the state. And that was enormously satisfying, I think. So I do agree that those forms of accountability are very satisfying, right? Seeing the state acknowledge that this is a harm by passing a law is very satisfying, which gets back to the reason, you know, these laws are therapeutic, not for they say we want to protect others, but the mission in such a law is not to protect others, but rather recognize that the state sees this as a crime, as an offense, you know? Who are they protecting? They're protecting people in the past, not in the future, right?
But why aren't they preventing future harm?
In a way, but it's so unlikely to happen that I would say 9/10 of this is saying that the doctor should never have done this, and 1/10, oh, doctors don't do this in the future, you know? Don't do this with embryos that you don't have permission to use. Don't do this with your gametes. Because the doctors are unlikely to do that now, unless you get a seriously twisted doctor.
I mean, they're not. That's a rhetorical question. But think about doctors are always human. Doctors are always making mistakes.
Yes, mistakes. Yes,
but that's a mistake too.
Yeah, it's a criminal mistake. Yeah, I think that they're statistically highly unlikely to do this compared to when they knew they couldn't get away from it or be they knew they wouldn't be discovered. But that remains to be seen. Maybe this is going on now, right? I do think that any proceedings like a restorative justice proceeding would not help, because that essentially happened in the Klein case right after they discovered, Maggie Jacoba Ballard, who is now public, said, okay, I'm going to call, basically summon all of Klein's relatives over Facebook and tell them what we've discovered and see what they say. And Klein's granddaughter responded, sorry, you must have the wrong person. But his son Doug, who's a lawyer, you must have loved this, and who actually goes to Jacoba's Catholic Church, said, okay, ask the priests is this woman trustworthy? Priest says, yes, absolutely. They started talking. He said, what do you want? She said, I want answers. He went to his dad, said, did you do this? Dad said, no, no, yes, right? And basically Doug participated with her in seeking accountability so long as his mom didn't know. And there came a point where, Doug arranged this meeting with the 8 siblings at a sports bar in Indianapolis. And he waltzes in and says, basically, I'm a frail old man. I made this decision to help people. What do you want to know? I did it 10 times. I did it 50 times. I knew you in your mother's womb. And she found that very unsatisfying. And that's when she decided to file charges with the Attorney General. And as soon as she became public, Doug backed off and said, I can't be part of this because my mom's going to get hurt.
Jenna?
So similar to that question, you use a really interesting analogy about the shield versus the sword. So I find with laws, they're a very good sword for people to seek redress and recourse, but often not a very good shield to prevent situations like this from happening in the first place. Mm-hmm. So when you think about, you mentioned on page 153 how Seeman talked about the jail sentence was insufficient. She didn't feel particularly punitive to him, mm-hmm. but wanted deterrence for the future. Mm-hmm. So I was thinking about, are there measures that you thought of that can be put in place, accountability measures that wouldn't undermine trust relationships between doctors and patients, and mm-hmm. also maintains the confidentiality, so mm-hmm. not putting another person in the room to make sure accountability is maintained. So something that I was thinking of was perhaps have on the spot DNA testing of the proposed donor, mm-hmm. And then also on the spot for upon insemination, and then as a safeguard then also mm-hmm. when the child mm-hmm. is born. Or could you see what problem with that would be, or what an alternative approach would be?
I think the problem might be that they have to get a lot faster, mm-hmm. right? I do think that the remedy lies in chain of custody, right? And making sure that these embryos or eggs or sperm, that if it's donor X, that it remains donor X throughout the process. And because what has happened lately is that a lot of clinics negligently mix up sperm or embryos or eggs, right? Mostly embryos. And the harms, the courts are not great at addressing those kinds of harms because it's too late, right? Another matter that you could do is give donors a donor ID on an international scale. So a US donor can't donate 25 times in the US and then go over to England and donate another whatever times. I think that allows, it doesn't get to the genetic identification right there at these multiple points in time, but it allows us to keep track of donors and ensure that they're not over donating. Does that make sense? Mm-hmm. And it doesn't violate the privacy interests, but right now a donor 257 from clinic A can go to clinic B and start all over again. Oh no, I've never donated.
Yeah, I want to come back to this insurance and information question, mm-hmm. because in the particularly where you have your rather strange health insurance in the U.S., there is a problem of what information the insurers can use to mm-hmm. grant coverage or not, but that's also true of jobs, that's true of a lot of things. Mm-hmm. So this comes back to this essential privacy question of how to enforce the use of information coming out of these cases mm-hmm. and in general, mm-hmm. okay? And what's your thoughts on that?
I mean, in terms of seeking accountability from the doctors afterward?
Yeah, you see, there's this accountability question, but there's also, once you know that you've got this whole thing, what is the responsibility
right.
To actually inform people, both for their health reasons, but also then, my God, you cost me my health coverage,
right.
okay?
Right.
Like theoretically, I've gone through some significant health issues without being bankrupt, because I live here in Ontario.
Yeah.
All right. I wouldn't want to have been in the States. I'm sure I would be dead.
Uh-huh.
But the point, the only point is that in your particular case, but it's the problem of not the control of the individual, but the control of everything. I haven't even thought about the embryo until you brought it up. Are you aware of the fact that in Hungary now, the state has taken embryos,
yes.
taken control of embryos and given them to other people without
yes.
the consent of the original people?
Yes,
and
exactly.
The difficulty is states can do awful things.
Yeah.
You know, given, you know, your own state doesn't impress a lot of, your own government doesn't impress a lot of us for their choices. And you know, I never thought I'd be sitting in this room thinking about Orwell.
Right. Yeah, no, I think, and what's going on in Hungary and Poland, Hungary has a lot of things going on because it's trying to bolster its population. But in the United States, we have Arizona, and Arizona basically said, they passed a law that said in divorce disputes, they will give regardless of what the couple contract, even if the couple contracts that the embryo is destroyed, if they divorce or if they die, the state will give the embryo upon divorce to the person who wants to gestate it, essentially. So to the husband, if he wants to use a surrogate, and to the mother, if she wants to, you know, use it herself to conceive. And this countermands all kinds of things, all kinds of forms of autonomy. Poland has laws that are also problematic. You know, they're not, I don't think they're taking embryos yet, but they're saying you can't use embryos even if they were your own unless you have this, for example, a single woman cannot use embryos using donor sperm that she created with her own eggs unless she gets a male to sign that he is the father of the embryos and assumes paternal responsibilities. So I think that the more information you put out there, right, for insurance purposes, I think the more problematic it gets in a country like the United States, where they're continually trying to undermine people's access to healthcare. I mean, access to health insurance.
Yeah.
Yeah.
You know,
So I have a couple of other students who had questions. I think some of these were already answered, but if those who feel the need to just tell them, and we can then wrap it up. Is there anybody else who wanted to say something, to ask something? No? You can certainly come after the presentation as well, or we're actually wrapping up. So I would give the two of you the last word if you have any more comments. No?
Well, not any more comments, but I'm realizing that a lot of the concerns around what we're discussing today, and you mentioned that a bit, is really tied with our understanding of parenthood,
Yes.
and whether it's a biological fact or a social fact. And I wish that's something we could explore further, talking about that, but talking about
Right.
the whole discussion about embryos too. So
there's also parental responsibility in the whole legal system for who pays for what, and that's a problem in all countries. Okay.
Yeah.
And you know, that needs to be addressed.
And in Texas, they're looking at bringing child support lawsuit against the doctor. Because again, they can't sue them for medical malpractice given Texas law, but they can say, well, you never were a donor, you never waived your rights, so here you are, here's the bill, right? I think one of the most fascinating things is when these cases first started coming out, people started seeing them as, oh, they're just weird oddities, right? But now that they're so pervasive, a lot of other questions emerged. I'd love to know historically if there was a venue where doctors got together and there was any coordination among these physicians. In the Netherlands, there were 7 other doctors who did this besides Carbat. 7. How many doctors did fertility treatment in the Netherlands at that point? So that might have been a coordinated effort, right, in some extent. But in the United States, we can't find any conference proceedings or anything else where they're discussing this. In fact, donation, how you procure sperm donors is a taboo subject, even in professional circles at scientific conferences. But I keep coming around to this fact that there's a lot of different lenses through which to look at these cases, right? And I hope groups of individuals start to explore these. I mean, it's lonely right now, right? But there's so much here to unpack in different countries and different contexts across disciplines. And I think what we learn from these cases tells us a lot about our assumptions about what sexual violations are, what parentage is, what the valid purpose behind a criminal law is, what harms there are, like how we conceptualize harms. I think it's an exciting issue to work on just from those perspectives.
A conference that we organized here several years ago, and actually has also come to my class. Barry Stevens made a movie, Biodad, which he discovered that he was created by sperm donation after his dad died, and made a documentary investigating where did they come from. And it's a fascinating story about the early days of artificial insemination, when even having artificial insemination was even so much more taboo.
Yes, exactly.
And it's interesting that there again it turns around the figure who was using his own sperm for implantation, and so it's a strange kind of desire of some to spread their genes, you know.
Yeah, and what is the harm? Like what is the stigma with male infertility? So if you had cancer and you were a male, nobody faults you for going to the doctor, right? And if you were infertile, if your sperm was faulty or not as healthy as it should have been, then why stigmatize the sperm in particular? Well, connotations of masculinity and things like that, but it's a fascinating example of how the stigma that was decades old still is affecting cases today, right? And our rhetoric, yeah.
On that note, please join me in thanking